Hello, everyone. Thank you so much for joining us today. I'm Marche, the webinar director here at Advice Chaser. As you're coming into the webinar room, I want to welcome you. And also, before we introduce our guests and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars, such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We're thrilled to bring you this educational presentation today, and I know we have a big crowd today. We're so glad to have you here. Just a few items. Attendees are muted, but we do encourage you to ask questions and leave comments in the chat box. If you ask a question in the chat box and we're not able to get to it, make sure to leave your contact information as well. If we can't get your question during today's event, we'll make sure someone reaches out to you after today. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. I'd love to introduce you to our moderator and presenter today. Our moderator is Mark Seither, a partner and wealth manager with Kingsview Partners in Knoxville, Tennessee. He has a Bachelor of Arts in Economics from San Diego State University and began working as a financial advisor in La Jolla, California. Mark enjoyed finding innovative solutions to clients' complex problems, and his desire to work with the entrepreneurial-minded helped him thrive as a financial advisor. As Mark honed his skills as an advisor and planner, he looked for a platform that would better pair with his desire to work with clients needing advanced planning and specialized fixes. He found his spot back in Northern California in early 2017 when he joined Trust CFO and assisted in integrating complex tax and estate planning with wealth and investment management. Since then, he has collaborated with Josh Saunders to build Kingsview Partners. Together, they assist individuals on wealth management and tax strategies. And Mark, I want you to go ahead and come on camera and say hello so people can see who you are.
Hey everyone, very excited for today's conversation. Small side note, when I was doing the asset protection planning, we had some very high net worth individuals come in and talk about their estate plan, and they'd show us what they had, and we'd be like, yep, that's an expensive piece of paper because it wasn't done properly. So this can be, there are very smart people out there who still get this wrong, and so I'm very glad that we have someone like Mike to come clear up some of the myths and mistakes that people make, and hopefully you can go forward and avoid those issues.
Very good. Thank you so much. Our presenter today is Mike Bennett, who is an estate planner with Encore Estate Plans. At Encore Estate Plans, Mike and his team assist financial planners to expand and offer more complete services, specifically helping them provide clients with a more comprehensive financial plan by incorporating estate planning. Their state-of-the-art software enables financial planners to quarterback the estate planning process with their clients while staying in compliance, mostly with revocable trust-based estate plans. And Mike, I'm going to turn the time over to you. We're glad to have you here and excited to hear what you have to say.
Well, yeah, excited. That's one word for it. This is still estate planning, so I will do my best to keep it as entertaining as possible. But I do want to encourage everybody to ask their questions. We definitely have material here to take us through 30, 45 minutes worth of stuff, but ultimately we want you to get what you want out of this. So don't hesitate to ask those questions. If it's something that's relevant to what we're talking about right then, it's something that we'll take on and address right then. If it's something that is going to be a little bit more detailed or isn't within the flow, it's something we'll push to the end of the webinar here. So with that,
we're already getting a couple. Oh, sorry,
wow.
Mike. We're
Go for
already
it.
getting a question in, but I know that there's part of the presentation that has to do with this, so we'll hold it off until then. I just want to acknowledge that you can go ahead and put your questions in. We might hold them until it's an appropriate time in the flow of the webinar.
And I see that question as well. So it is something that I'll make sure to hit on more on that part of the presentation or the webinar here. So first myth, as you can read, that only older rich people need estate plans, and that's just simply not true. I'm going to use my own personal example a lot through this process. So I'm a 43-year-old. I'm married to Sarah, who's 42 years old, and we have 2 kids that are 12 years old and 10 years old. I can assure you that when we first did our estate plan, we were neither old nor rich. We were just, you're going to hear me use this word a lot through the process or through this webinar, and that word is control. If I can boil everything that we're going to be talking about today down to one word, that's the word, control. We're controlling who gets everything. We're controlling how they get it. We're controlling who makes financial decisions if we can't make them for ourselves. We're controlling who makes healthcare decisions for us when we can't make them for ourselves. And the 5th one is we're also controlling who would have any custody of minor children should the worst happen to us. So when my wife and I first did our estate plan, it was motivated by that very last question, guardianship. Who would get our kids if something happened to the 2 of us? That is a huge, huge thing for younger couples that are just kind of starting out. And that's something that it's often one of the most colorful conversations between a husband and wife as well, when you're trying to figure out who's going to get the kids. Additionally, the other thing that we listed on here is that it's not just doing a will, it's not just doing a trust. Those various aspects of control also go into healthcare directives, financial powers of attorney, and a number of other things. Next, the second myth that I see on here is that, yeah, if I die without an estate plan, what's going to happen? And, this is, again, it goes back to taking control. When you do an estate plan, any type of an estate plan, you're exerting control over your situation. If you die without an estate plan, your state's probate code will dictate what happens to your assets. There's also, they will dictate what happens to your children as far as a priority goes. They don't just go to the state. Your kids will not go to the estate. But if you, for me, again, 12-year-old and a 10-year-old, if I didn't want my kids to get everything at 18, I need to take more control over my situation. And so that's a huge, huge thing. For my wife and I, we've decided that, our kids, they get to control their assets once they reach certain ages. 1/3 at 25, 1/3 at 30, 1/3 at 35. And there's payments for healthcare, education, support in the interim. And those are the types of things that with an estate plan, you get to take that control. And don't worry, not only can you take that control, but you can also make changes to those things as well. I joke that when my kids are teenagers, I'm going to change those ages to 55, 65, and never when they control things, because they're going to be knucklehead teenagers at that point in time. But again, the point to take from this slide is that the state will dictate what happens. And just based on your state's probate codes at that point in time. The next thing that we often hear quite a bit is that a will avoids probate. Just to back up a little bit, probate is just the legal transfer of assets when somebody dies. It is a court approved, not a court approved, it's a court process that basically dictates what happens, when it happens, what notices you have to give to who. And people don't like probate for a number of reasons. The 3 biggest reasons they don't like probate are the expensive nature of it. In certain states, these things can be very expensive. Where I am in California, if you have a $500,000 probate, there's $13,000 in attorney's fees. There's $13,000 that goes to the executor, and about another $3,000 to $4,000 in court costs. That's terrible. The second reason people don't like probate is the amount of time it takes. In most states, probate is going to take a minimum of 6 months, but in a number of them, it's 9 to 12 months, and that's if things go well. And so that's not a very welcome scenario. The third reason that people do not like probates is that it's not private, and that's the type of thing that it's imagine being able to see your neighbor's assets as part of a probate proceeding. We did just get a question in about executors. Yes, this is all part of it. Choosing the person who's in charge of your finances. For a trust, that's the trustee. For the will, that's the executor. For the power of attorney, that's your power of attorney. That's all about taking control. There's a lot of ways to avoid probate. You see on here assets with a valid beneficiary designation. So if you have a retirement plan that names your spouse as the beneficiary, and then potentially your kids as a contingent beneficiary, that asset will not go through probate. That asset will pay directly to those beneficiaries upon your death. The second category on there is an asset held in joint tenancy. So if you're married and you took title to a property with your spouse as joint tenants, that will also not go through probate. The third category of assets, and the most common way, frankly, that people attempt to avoid probate and to take more control over their particular situation, is to have your assets held in trust. And so those types of assets will not go through probate. And the amount that goes, each state has a different level of assets that have to go through probate. So that's going to vary depending on your state law. It can be as low as 25,000 in some states and as high as 200,000 in some states. And then anything below that doesn't have to go through a formal probate. So we're talking about avoiding probate quite a bit. And so I have heard clients that will say, oh gosh, well, I just said in the previous slide that if you have someone joint on an account or on an asset, that will avoid probate. Yes, that does avoid probate, but it also creates some other potential issues. For example, if I had my child on my house, if I wasn't married, add one of my kids on there, that's great. I'm going to avoid probate with that asset. But if that kid later gets in a car accident or has creditor issues of their own, it's as if they own that home. And now that creditor can come and take my home. So I've avoided probate, but I've created a potential issue there. Additionally, if I add my child to my home, that's a gift. And we're not going to dive too far into what a taxable gift is and what that even means, but that is a gift that I've made to that child that would potentially have gift tax or income tax implications for myself or for my children after I die. And then finally, the post-death issues that are listed on there. An example of that, as I said before, I've got 2 children. Let's say I put my daughter on the house with me, and then I die. And let's say I have a will that says everything goes in equal shares to my kids. Well, that asset that I've put my daughter on goes straight to my daughter. It does not go as part of the will or as part of my trust. And so that is a common, it's a myth. It's a myth that on which one trumps. But if I've named one person on that asset, it goes to that person. It does not go pursuant to the terms of my will or pursuant to the terms of my trust. So you may have just created a potential issue between your kids by just trying to avoid probate. So you want to avoid probate, but you want to make sure you're doing it the right way. Next, one of the mistakes, the next mistake that we often see is something related to incapacity. Everyone talks about, well, God, what's going to happen when I die? And but less often I have people coming into me and saying, well, I'm worried about what happens when I become incapacitated. And so we've already gotten a couple questions in this realm. And so these are the types of things that you can, that I think need to be planned for and aren't planned for enough. And so one of the things that you do as part of a good estate plan is, again, you dictate who will make financial decisions for you if you can't make them for yourself. If you're alive, there's several ways to do this. One is through your financial power of attorney. A financial power of attorney is going to control who makes financial decisions for you in the event you cannot make them for yourself on assets that are not held in a trust. If your assets are held in your trust, your successor trustee will be the person who helps you manage those things. Now, the successor trustee and the financial power of attorney are often the exact same person. The goal for a lot of this stuff is to make sure that you have the same people pulling on the same rope in the same direction. And so it's much simpler if you've got the same person doing those types of things. And so that's those are the types of things that we can easily incorporate into a basic estate plan. The next one on here that we've talked about is healthcare decisions. So when it comes to control, that was the fourth one I talked about. Who's going to make healthcare decisions for you if you can't make them for yourself? When I try to talk about these things, a lot of people ask me, well, who makes a good healthcare agent? What I try to tell them is that you need someone who can make a difficult emotional decision at what is obviously a difficult and emotional time. And they're going to do what you want for you, even if it conflicts with what they want for you. In English, on my own advanced healthcare directive, I have my wife first for the obvious reasons. I mean, she's my wife. I do not have my mother listed. If I'm ever in that position, I want someone who's going to be able to, I don't like this terminology, but I use it because people get it. I want someone who can pull the plug if I'm in that situation. And I know my mother would never do that. And I love her for that. And I'm very grateful for that as well. And so I'm not going to name her because I know that she's not going to follow my wishes. Doesn't make her a bad person, but it makes her a bad healthcare agent for me. On the complete opposite side of the coin, I don't have my father-in-law listed either because he'd put a pillow over my head if I gave him that opportunity, and we can't have that either. And I joke about that. I mean, he loves it that I use that example, but it's something where we can't. I use it to make a point. But you can see that point because it's a common misconception out there is that if I pull the plug on there, that it's legally binding on people. It's not. It just lets people know what I want to have happen and if they're looking at that document, I'm in a place where I can't speak for myself. And so that's, it's very, very important to have people on here. They're going to carry out your wishes. Yeah, and then next one here, this myth. It's never been easier to get an estate plan done. And that is mostly a positive, in my opinion. I say mostly a positive because now that there's more options, some people don't get to the correct level of service that they reasonably need. So if you've got, on one end of the spectrum, you've got your complete do-it-yourself options, the LegalZooms of the world out there, which it gets a bad rap, but it can be a good tool for certain scenarios where you just need to get something in place. And so I'm not going to completely poo-poo on that because it's something that it's something where it does have its place. On the other end of the spectrum, you've got people who say, well, no, I need to have a lawyer do everything for me. And I need to go sit in that lawyer's office, spend thousands of dollars to get it done. For certain people, that is the exact thing that you should do. And so there's those two ends of the spectrum. There's also services out there that you can use where you can work with a financial professional that will assist you in getting things done. But will not necessarily, you'll get the efficiencies of the LegalZoom software with some of the expertise of what the estate planning attorney does. So there's a lot of different options out there for getting these things done. But if you're not sure, on who is a good person or where you need to go, ask. And maybe not ask the attorney's probably going to tell you, yeah, well, you got to do this. If you go into a live chat at LegalZoom, they're probably say, yeah, we can do that. So I mean, ask people around you that you trust, whether it's a tax preparer, your financial planner, other people that that can help you through something like that. And so what I said before at the outset is that a lot of times what we really, really specialize in doing for most people is a revocable trust-based estate plan. And some of the pushback that I get from that is that it will complicate your life. And it really doesn't. Having a revocable trust, it's, it can be long. I've seen some of them as short as 3 pages, but generally they're going to be 20 to 30 pages long. I've seen some of them that are over 100 pages for a basic estate plan. And just by that very nature, it seems like it will complicate your life. And I often tell people, though, that no matter how long your trust is, 80% of it you're never going to use. The problem is I don't know which 80%. People like Mark and I, we get paid to worry when we have no reason to worry. So we've got to do things to make sure that we are that we're protecting for the unexpected without going too far overboard on these things. But at the same time, having the trust, there is an initial complication period or an adjustment period that as we put it in there, where you do have to put those assets in the name of the trust. You have to make sure that your bank account is in the name of the trust. You have to make sure your real estate is in the name of the trust. All those things, that is an initial step that you have to do, but it's a very important step as well. Just making sure that part gets done. But after that, you still file the same tax returns every year. There's not a whole lot of maintenance that you have to do on it unless your life changes. And going on to the next slide here. I was referring to this a little bit in the last slide, is not putting those assets in your trust is a mistake. So what I like to say here is that a trust is only as good as the assets that are actually put into it. And so it's, if I don't put my home in the name of my trust, if I don't make sure that things are going the right way for me, it's great to go get this trust in place, but you got to make sure you do it right. And that's where, there are, again, when we look at the spectrum on who or how to get these things done, and this is one of the fears of using a straight software solution, and where you're completely doing it yourself. That's one of the fears, is that you're not going to know these things, or you're not going to know how to do it, or you're not going to feel supported in a way to have that done. And that would often lead people to go see your local estate planning attorney to get these things done. But there's a lot of times where that local estate planning attorney is not going to do that stuff either. So just make sure that you're pressing on those issues and making sure that you're asking those questions to make sure that everything is being done appropriately. Now, any good estate plan is going to have the backup documents in place to make sure that if you don't do it, we've got you covered as well. As I said before, Mark and I, we get paid to worry when we have no reason to worry. And our backups have backups. And so we make darn sure that you're being protected in all facets on this. And then moving on to number 9 here, a lack of coordination between the assets and the estate plan. This part is huge, and so many different, on both the basic levels and also on the more complex estate planning type issues. This lack of coordination can just be devastating to your estate plan. For example, for my 12-year-old and 10-year-old, for my life insurance, my trust is named as the primary beneficiary of my life insurance policies. Now, why is that? Well, number one, if something happens to me, I want my spouse, who's the first person who gets everything in my trust, that she would have access to all those things. That's great. I could have just named my spouse to get there as well. But one of the reasons I named the trust is, again, because I get paid to worry when I have no reason to worry. If something happens to my wife and I together, that goes to my minor kids now. If I've just named my children, my 12-year-old and 10-year-old will get all that life insurance money when I turned 18, or when they turn 18. Now, if you recall, I told you that I don't want them getting it until they turn 25, 30, and 35. And so that lack of coordination between the life insurance policy and the estate plan can completely defeat the purpose of what we've tried to accomplish with our estate plan. And that's, again, that's the type of thing where it can just be devastating to a plan if you don't do that part right. Additionally, another big mistake that I see as it relates to tax planning, if you're charitably inclined, someone like Mark, who has such a background in taxes, he's gonna, this type of thing would make him, just shake, I'm sure. But where, if you have a lot of money in your retirement accounts and you're charitably inclined, it's always better. I shouldn't say always, because there's always exceptions to every rule, but generally speaking, it's going to be better to give those types of assets to charities, because although most inheritance is not taxed, if your individual beneficiary is a person who takes that money out of that retirement account, they will be taxed on it. And so if instead you give that money to charity, that money's not going to be taxed because charities don't pay taxes on those types of things. Another one that I've written in here is the special needs beneficiaries. If you have a beneficiary that has any significant special health needs, that's making sure that that's done the right way is going to be very, very helpful for that beneficiary down the road. And it's not something that is as difficult to plan for as you might think. You can build special needs language into any revocable trust-based estate plan. And so it's something where if you do have a beneficiary that has special health needs and they're on any need-based public benefit, Medicaid type program, those are the things you have to make sure that you plan around. And then finally, the other thing I have on here is giving access to one child via beneficiary designation. So going back to my example where I put my child on one child on my house, but not the other one. If I die and I say everything goes in equal shares to my 2 kids, well, and if I put one kid on one bank account or on the house or whatever, well, that goes outside of that 50-50 split. And so now that child has now gotten that asset, plus they're going to get 50% of everything else, which is often not what you're trying to accomplish. The final mistake on here, well, there's a lot more mistakes. These are just the most common mistakes that we see out here. Never reviewing your estate plan. So if you're one of the people on here who actually has an estate plan and hasn't updated it in some time, a lot of people will ask me, well, how often should I update it? And that's a tough question because I can answer almost every question that you ask me with it depends. But I try to give something a little bit more than that. If you've had a significant change in health or wealth, that's a good time to look these things up again, to go through these things again. If you know that you're looking through your estate plan and you have no communication with the person who you've named as a guardian for your minor kids, that's a problem. It's time to get that updated. If you've got a kid who's spinning their wheels a little bit and isn't ready to take over, maybe you've named them as your successor trustee. That's the type of thing that, gosh, you gotta get that. You got to get that updated, or you got to maybe put more restrictions on that child. For those purposes. So there's just so many different reasons to get these things updated. So it's always a good idea. I mean, as a general rule of thumb, I mean, I hear people say 3 to 5 years. I'm okay with that, but don't wait 3 to 5 years just for the sake of waiting 3 to 5 years. If something big happens or you're not sure, that's when it's time to look at those things again. But yeah, some of the other things, you might be more charitably inclined. You might have just different reasons out there for, you want to leave more to your grandkids than your grandkids. You want to make sure you got provisions in there for your pets. Those are all different things that we often see for that. So that's all we've got on that. The key takeaways again. I think I only said it like 47 times during this 30 minutes or so, but control. There, now we're up to 50. That's what we boil all of this down to in one word. The 5 things that you're taking control of are who's getting everything, how are they getting it, who makes financial decisions if you can't make them for yourself, who makes healthcare decisions for them if you can't make them for yourself, and who's the guardian of any minor kids. So those 4 or 5 things to take control on are huge when it comes to doing your estate planning. And then you see the other ones on there, but get it done, make sure it stays up to date, and just don't ask. Just don't hesitate to ask questions on these types of things. And I am going to stick around for questions. We do have several questions in the chat. And so it is something where if you have more questions, don't hesitate to keep chatting on here.
Yeah, we'll jump into that now. So a lot of questions coming through. One of them was involving updates and changes to the will. The person was asking if I in my later years have dementia and someone convinces me to change my trust. Is that possible? Is there ramifications for that? How does that play out?
So everything's possible. It's definitely shady on that type of issue, but those are the types of things that the terms of art that are used out there are undue influence. That if someone is unduly influencing you, the other beneficiaries may have a cause of action against that person after you're gone, or once they find out. And that's also elder abuse as well. If you're if you're convincing someone who doesn't have the capacity to do it. Also, if you're working with a professional, professionals are going to ask several questions if they're worried about that type of scenario. You know, when there's been times where I've met with clients way in the past where, you know, I'll purposely ask questions to trip up someone who I worry about as being potentially incapacitated, and to try to trip them up to make sure that they know what they're doing. If someone brings anyone into the office with them to do an estate plan, one of the first things that a professional estate planner will do is ask that person to leave the room. So it's just the estate planner and the client working together. You know, those types. So there's a lot of different things that, I mean, all these things are possible, but you hope that you surround yourself with the right people to minimize the chances of something like that happening.
Yeah, yeah. And then we had another one come in about if I pass and the person was asking if their spouse survives them, all the funds go into the trust, and then they remarry. Does their spouse's new husband get access to the trust?
So I'm going to start off with my blanket answer. It depends, and I hate that answer, but I always try to expand on it. It really does depend, though, on what the terms of the document state. That person is not, that new husband, the new wife does not automatically get access generally, but there are certain times where, you know, they potentially can. There are ways within the trust to do, this is probably they're family protection type things. You know, we jokingly refer to them in our office as bimbo and pool boy clauses, but those are the types of things that you can build in to make sure that, or not make sure, but to minimize the chance of something like that happening. So you do have the ability to you know, to do that, to minimize those chances.
Okay, perfect. And then regarding probate, we had some people asking, you know, early on about the length of probate, and you answered that question. And I've actually, you know, personally seen probate cases go much longer than 9 months, especially during COVID, because we're restricted to the court's hours. But someone was asking if the probate case gets finished and you're just generally not happy with what was dished out or decided, is there any way to reopen it?
I mean, once the court has ordered the assets to be distributed and the probate closed, that's that. Now, a lot of times beneficiaries who are getting along, they can come to some sort of an agreement on that, on what they want to have happen, but it needs to be 100% agreement to go to the court. Otherwise, the court's just going to carry out the terms of the will if the will is present, or they're going to carry out the terms of the probate code if there's no will present.
Yeah, and then this will be a good scenario to play out too. So someone was asking specifically if their adult children are already set as beneficiaries to take over certain accounts or beneficiaries on life insurance, and their will has already stated, hey, I'm, you know, just sell the house and dish out the proceeds. Is a trust still needed in that scenario?
You know what my initial answer is going to be, but I promise I'll expand on it. But
I think we're up to 53 now. So, or no,
yeah, well, that's control. Yeah, control. It depends.
Yeah.
That's all I. Yeah, and so there can be scenarios where a trust is not needed. In that situation where there are no minor kids, they're already named as beneficiaries on things. Now, that you did mention a house in that one, Mark, where you know, there are, I believe it's like 25 or 26 states that do allow beneficiary deeds, and so you can file a beneficiary deed where it operates the same way as a beneficiary designation on a life insurance policy. In cases like that, you may not need to do it because you're not looking to, you know, you're not looking to control how they get it. You're just saying, go ahead and take it. if they're adult kids who are reasonably responsible human beings, I would potentially argue you don't even need a will potentially and something like that. Now you still want a power of attorney and you still want a healthcare directive to make sure that there's provisions for your incapacity. And more often than not, you're still going to probably do a will just to make sure that you've covered everything. It's easy to give a blanket answer. Yes, everybody should have a trust, but no, that could be one of those scenarios where you may get everything that you need from the will standpoint, but make sure that house is covered, because if the house is not deeded by beneficiary or anything like that, then that could potentially go through probate.
Yeah. And then what happens if someone dies and they don't even have a will in place?
It's if they don't have a will in place, that's the probate. That's where assuming that the assets are there for probate, but the most probate codes are going to give a priority on what happens there. So if that person was married, there might be a set aside for the spouse. If it's a community property state, there's 9 community property states out there, 41 that aren't. Those might be a little bit different there. If there's no spouses, it might go to the kids. And then you start getting into situations like Prince, where he died, that there was kids who were coming out of the woodwork. You don't know what's going to happen there. If there's so it's going to go pursuant to state law is really what's going to happen eventually.
Yeah, and then we had another one specifically around the executor position. Someone was asking, hey, am I able to just dictate in my will, hey, the executor is just going to decide who gets what and divide things equally? I'm not going to be part of that.
So I would argue that that's a terrible idea, because one of the reasons you do an estate plan is so you can take that control. Why give that control to somebody else? And so, I guess technically you can, but that's a lot of responsibility to give to an executor or to a trustee on a trust. Wow. So what happens when they decide to give everything to one of your kids, but not to another one of your kids, or to one charity that they like instead of the charity that you like? Why wouldn't you take control? I guess is what I would argue in a situation like that.
Yeah, and on that topic of control, we did have someone ask, can you repeat the 5 things that you want to control in an estate plan?
Yeah, who's getting it? How are they getting it? Who makes financial decisions? Who makes healthcare decisions? And who's the guardian of any minor kids?
Yeah, which actually goes really, transitions really well into the other question that came in, which was, if my spouse and I cannot decide on a guardian, is there a way to finish the process with that, and add that later?
Yeah, rock, paper, scissors is how you decide. No, in a situation like that, and this comes up quite a bit when you have like a couple who's like going on vacation or something like that. It's best just to get somebody down. What I see, and I don't want to give a blanket answer on something like this, but you can finish it. But again, or you can finish it without that, but I feel like it's incomplete if you don't finish it. Or if you don't put that part in there. And so that's the type of thing that I see some spouses. I think the most common result in a case like that is where they will name co-guardians, which I will tell people that the benefit of having 2 people like that is they both have to agree on things. The downside is they both have to agree on things, but maybe one parent picks one and another parent picks one, and you have them together, and at least you have something down at that point, which is better than nothing. But at the same time, man, it's the guardian that's generally the hardest question that the clients have to answer when it comes to estate planning is who's going to get the kids. In my case, it's who's going to take them, but that's a different problem.
Yes, and then this one came in, it's a little bit more specific on the guardians. If they were to name guardians and they're unavailable for a certain period of time, right? Let's say they're out of the country. What happens to the kids while you're trying to locate the guardians and get them back to where they can get the kids?
Yeah, great question. Wow, it's generally they're going to be able to find them right away. They just may not be able to step in right away. And so that guardian, if they can't step in right away, they don't necessarily have to step in. For example, I had clients about 10 years ago who passed away suddenly with a 20-year-old and a 17-year-old. The 20-year-old was named as the guardian. Well, the 20-year-old was away at college. And so what the 20-year-old did was they moved in their 17-year-old sister with, with her best friend's family, who lived right across the street. So the 20-year-old didn't have to come home from college, even though she was the one named. She made the arrangements, though, for her 17-year-old sister. And so that's, so just because you're named as guardian doesn't mean that you're the one who's actually going to take the kids in. That's generally the case, but there are ways to, where they're just in charge of that.
Now, also someone was, referring to your, 30, I think it was 25, 30, 35. If there's an inheritance and a life insurance death benefit for the kids to eventually get, who controls the money? And is there any way for the kids to get access to the money early if needed?
So it depends, of course. I hate that answer. I really, really do. And all evidence.
You shouldn't have become an attorney, an estate planning attorney then.
No, that's brutal. So generally what it's going to say, what a trust would say, is that there's access to that money for things like healthcare, education, support, and maintenance. And so if they're away at school, the money's going to be there for the kids to go to college. You're not going to have to take them out of college because there's no money there and it says, oh, you can't get it till you turn 25. On the reverse side, there's generally going to be, I'll just be a little bit blunt about it, but drug addict clauses in there, where if it says you're supposed to get it at 25, well, we can postpone it if it makes sense to do so, if the person's just going to kill himself. If they were to get access to that type of money. But hopefully that answers that.
Yeah. And then this one came in from more than one person regarding, as you make updates to your wills and your trust, do you have to keep previous records and provide all of them when they're needed?
So for wills, I'm going to break that one up a little bit. So for wills, generally the first line in a will says, I hereby revoke all previous wills that were done. And so generally, now you do have to, so sometimes people do what's called a codicil to a will. Codicil is just a fancy word for amendment. People in my industry, we have to make up words like codicil to make ourselves sound smarter than we really are. But that's, there we go. And so if it's a codicil to a will or an amendment to a will, then you have to keep that stuff going. If you've done a will that revokes all previous wills, you don't have to keep the old wills. The only reason why it would even be remotely relevant is if someone is questioning your mental capacity or is challenging that will after you die. Then if that will ends up getting thrown out, then it would revert back to the previous will. That's a very uncommon scenario, but it's, again, I get paid to worry when I have no reason to worry. On a trust, you can do an amendment to a trust, in which case you do keep those things. Now, you can also do something called a restatement of that trust, where you still keep the trust, same trust name, the same trust date, but it wipes out all previous amendments and it wipes out all previous documents or all previous trust documents in there. But it's the same principle in that if that later gets contested, it would revert back to the old one. But there's a lot of people out there that will do a restatement of their trust, because they don't want one of their kids to see that they were cut out previously, but now they're back in, something like that. They don't want to, reopen those wounds. And so we do see a lot of people do those restatements.
Okay. And then we had another one on, let me scroll up because it was a little ways back. Essentially,
someone like dual executor in healthcare. I feel like that's a good one.
Yeah. Can you elaborate on that?
Yeah. So that, and I said it once, but what I like to say is the upside of having multiple executors or multiple healthcare agents is they all have to agree on things. The downside is they all have to agree on things. And so it can be a double-edged sword for sure. And I'll have some people who will say, well, gosh, healthcare, I'm going to name all 3 of my kids and the majority rules. And I say, okay, well, that's great. How do you think this plays out in a hospital? 2 of them want to pull the plug and one of them says, no, I'm going to sue everyone in this hospital who's ever seen my mother if you pull the plug. Well, the documents say majority, so they'll pull the plug. No, they won't. The healthcare facility is not going to do anything until all three of them agree.
Mhm.
And so what I try to encourage people to do, if they're willing to listen, or what I hope for clients, is that you pick one person who's going to make the right call. They're going to get the input from the other stakeholders, the other kids, whoever it may be. But ultimately, they're going to have the only vote that matters. But they're not going to be the type of person who's going to tell their other family members, I've got the only vote that matters. You want someone who's going to get that input, get that buy-in from everybody, and who's just going to make that rational call. But if ultimately it comes down to it and people are not agreeing on things, they're going to make that tough call. And a lot of these things, like for healthcare, they're not necessarily making the call. They're just carrying out someone's wishes, which is a different way to look at it.
Yeah, no, completely. And we also had someone asking, hey, so if the executor has, if they're the ones, dividing everything and giving assets to who, the trust dictates it should go to, what's the time frame that they have to complete that by? And when they get done completing it, do they have to show everyone what everyone else got? Or is it just, hey, you get this, and here's the document saying that this is all you get?
So generally speaking, and I don't want to go into a specific state's laws because it's going to be different across the country, but generally speaking, you're going to a trustee or an executor is going to have to account unless that's been somehow waived by the beneficiaries or by the or by the documents. But and so ultimately, though, it's even if it's waived by the documents, they may still have to do it if there's allegations of fraud or other things. But if you're getting 1%, you're getting 1% of an estate. Well, 1% of what? So you should get to know those types of things. Now, if I'm getting, if someone's given me in their documents, it just says $5,000, I shouldn't have any right to see anything else, provided I get that $5,000. I don't need to know anything else. Now, usually most states are going to say that you do have to give a copy of the trust to every beneficiary, at least every beneficiary, and a lot of states will expand that to heirs as well. But if you're a beneficiary, you're going to be able to see who's getting what. But again, if I'm getting $5,000 and then there's all these other people getting percentages, I should have no rights to see anything other than that because I've got my $5,000. The rest of it's none of my business.
Yeah.
Oh, and as far as timing goes, I didn't address that question. Most states are going to say a reasonable amount of time, which it depends. Reasonable, those are just terms that can drive you nuts. But what's reasonable is going to be based on the facts and circumstances of that particular trust. I've seen trusts where it's frankly reasonable that it's gone on for 3 or 4 years because they're waiting to sell property or waiting to they can't sell a business because they just can't find a buyer. And then I've seen trust administrations wrap up in a day where it's, hey, look, it's all the money's there, we all agree on things, I've seen all the account statements, let's just get this thing wrapped up.
Yeah. And then this one will help us differentiate between trusts too. Someone was asking, hey, they had been told that their father, the estate wasn't big enough to put it in an irrevocable trust. Can you dive into the difference between irrevocable and revocable trusts?
Yeah, so the basics of it are: revocable trust is set in sand, an irrevocable trust is set in stone. Unless you go to court to change it. But that's the basics of it. Revocable trust, you can make changes to it while you're living and while you have the mental capacity to do so. An irrevocable trust is generally done for asset protection purposes or some other estate tax reasons. There's some other bigger purpose, or like Medicaid type planning. Those are the reasons why you would generally do an irrevocable trust. But you have to give up control in order to get those benefits. And so you have to, I hear a lot of people that say, well, I want to make sure that all my money doesn't go to the care home or whatever it may be. And so I want to do an irrevocable trust. And I'll look at them and I'll say, okay, well, so you're willing to give up control of all your assets? Well, no, I don't want to do that. I just want to make sure the healthcare facility doesn't get it. Okay, but in order for it to not be your assets, for them to come after those things, you have to do you have to give up that actual control, and then that usually stops that in its tracks. But and again, that's very, very general. I don't want, I mean, we said at the outset, don't rely on that, the statement to say, oh yeah, well, I need to do an irrevocable trust, or I don't need to. But
Yeah.
yeah, it's revocable trust-based estate planning is the most common avenue. Irrevocable, it's something where there's got to be a reason outside of just control.
Mm-hmm. Yeah. And then, okay, perfect. And I would add to that scenario too, like actually sitting down with an attorney and getting really good information on that, especially someone who specializes in the Medicaid Medicare arena, because there are also certain, and rightfully so, things put in place to make sure people don't just dump all their assets, and all of a sudden you have a $10 million estate that vanishes. And it's like, oh, I qualified, right? So there definitely does have to be a lot of guidance, a lot of education, before you, again, just go give away control, thinking that that'll solve all the problems.
Absolutely. And that's the type of thing that just because someone has a legal background like myself, I mean, that's the type of thing where I'd be telling someone, no, I've got to refer that out to somebody, because you're right, Mark, you got to have a specialist there.
Yeah. And I love people who can specialize on that, because that is another, some of that literature will put you to sleep.
It's even more. Yeah, that's a whole can of worms.
Yeah. And then we had another one come in about how do I, or what's an effective way to approach elderly parents on this topic and getting this going?
Well, it used to be that the hard and fast rule was don't. But thankfully people are communicating a lot more about these things. And it's so hard because every family is different. I jokingly tell people that I've been doing this for almost 20 years. I've never met a normal family, and you won't be the first. There's no such thing, and that includes my own family in that. And you're going to know your parents better than your financial professionals ever will, or someone like me ever will. But really, I think it's encouraging them to take control over these things. It's not protecting your inheritance. It's doing something that's right for your parent, and it's just the right thing to do. And so I think going at them in a way where you're saying, hey, look, this is your opportunity to take control over these things, because that will just it'll help you and it'll help us. It's a good family thing to do.
Mm-hmm. Yeah. And then another one just came in about is the executor responsible for communicating all of the estate plan and probate assets to the beneficiary, or is that something that the courts provide everyone?
So the executor is ultimately responsible for preparing a lot of those things, and it's not something they can avoid. I mean, the probate code sections within each state are going to say what information you're required to provide, and the court's going to hold your feet to the fire on those types of things. It might take longer than you want it to, but ultimately they will be holding your feet to the fire on that stuff.
All right. Well, we've had a lot of great questions. I'm going to have to end our question and answer portion right now. And I do want to say, if our audience has not had their question answered, go ahead and leave your contact information so that we can reach out to you after today's event to address that. There was another question here that I answered in the chat, but I wanted to let everyone know that there will be a link to the replay of this event available to you, and you'll be able to share that link with friends and family and watch it over again if you want to review this information. So on behalf of Advice Chaser, thank you so much to our speaker and to the organizations that have worked with us to bring you this webinar today. Thank you so much for attending. To our attendees, again, great questions. We're so excited we had such a crowd here. Let me go ahead and save this chat. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Well, we're getting a lot of thank yous from our audience. Another question, how can I watch? We will be sending out a link to the replay of this event. It will also be available on our website in about a day or so. So again, thank you so much for coming. And we have lots more webinars in the future, so we will see you at another webinar soon. Goodbye, everyone.